Court of Appeals, Division 1.
Not that.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV 190382, Wood Expressions versus AAA Alarm and Security and ASI Communications. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your presentation. Presiding Judge McMurdy will be viewing the proceedings via the live stream to adhere to social distancing parameters, and we both have I've got my iWatch and he's got his computer. In case he has any questions, he'll be emailing us. So if you see us looking at our devices, we're trying to field Judge McMurdy's questions. All right, each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs, discussed the case in conference, are familiar with the facts, and I'd like you to take that in consideration during your presentation. At this point, I see you all wearing masks, and I do appreciate it. I think we're all 6 feet apart from each other, so if you want to remove your mask while arguing, please feel free to do so. Please also stay at counsel table. We're not going to move around. That's why you have the microphone in front of you. It's a bit awkward. It feels strange, but just go ahead and stay seated and use the microphone at your table so we ensure Judge McMurdy can hear us. All right, any questions about proceedings, procedures before we get started?
Not from the appellant, Your Honor.
All right. Everybody feels comfortable and appropriately socially distanced. Excellent.
Yes.
And counsel, when you're ready.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal. Obviously, may it please the court, obviously this case involves, at least to a great extent, the public policy exceptions to exculpatory clauses. The restatement of contracts, the restatement second of contracts, Section 195 provides that, quote, a term exempting a party from tort liability for harm caused intentionally or recklessly is unenforceable on grounds of public policy, unquote. And as we all know, generally, Arizona follows the applicable restatement unless there is direct contrary authority. The case which comes closest to adopting restatement section 195 is the air freight case cited in our briefs, 215 Arizona 103, which case both parties in the court below failed to cite in the summary judgment briefing. So with respect to, I would break this case into the following issues. First, gross negligence, and that being an exception to an exculpatory clause. Second, the additional exceptions, particularly bad faith, that were incorporated by the air freight case. And third, if there is no exception to the exculpatory clause, what is the scope of the waiver of subrogation clause? I think the first issue is the most important, which is gross negligence. This leaves aside the whole air freight case, okay, which both, as I said, both...
I'm sorry, I missed that. This does what?
I'm sorry, what, sir?
I just didn't hear the sentence.
I said this first argument, gross negligence, essentially leaves aside the air freight case. It's not even necessary to get there, okay? Because if we accept the concept that gross negligence is an exception to the exculpatory clause, a public policy exception, we don't even need to deal with the air freight case and the fact that it wasn't cited in the summary judgment briefs. So then the question is there a question of fact on gross negligence that could have gone to a jury? We would respectfully submit that under the record here, there is at a minimum a question of fact on the presence of gross negligence. If you look at our reply brief, page 12, we summarize 5 pretty critical admitted points here, which doesn't require a jury. These points would not require a jury to, I'm just keeping track of my time. These points would not require a jury to find gross negligence, but they certainly would allow a jury to. One, that, as part of this contractual relationship, there was a promise of continuous monitoring, which clearly under the facts did not take place. 2, the clear indication from the contract is AAA was going to do it. So I'm assuming you're familiar with Wood Expressions, AAA, and then subcontracted out to this ASI. So Yes.
To that point, you said AAA was going to do it, and ASI, in fact, is the one that did the monitoring. So when we look at that, in this contract, do you see something that would have precluded AAA from subbing that out, the monitoring?
No, there's no reason that they couldn't, but they probably should have disclosed it, okay? It's simply it's one of 5 points. One, they promised continuous monitoring and failed to tell the customer, well, we're not really going to monitor it if there's a test fail. That'll just be an automated process, and we'll tell you about it. I mean, we'll tell you about it when we get an email. If that's on a Saturday, then we'll get an email on Monday morning. So then the fact that there was no disclosure of the fact that it was delegated ASI. Third,
the disclosure, I mean, it doesn't really matter if it's their own employee or they've delegated it to someone else.
It probably isn't that. I would agree with you. It's not that
the person who
critical
signed
of
the
a fact. Although, again, we're talking about what difference it would make to a jury, okay? And we've all tried cases, and sometimes juries pay more attention to what seem to the lawyers as inconsequential facts. If I was presenting this to a jury, I'd hit the 5 points that are on page 12 of our reply brief. The promise of continuous monitoring, the undisclosed delegation, the fact that they don't monitor test fails, that it's an automated process. Number 4, and we got this from the admissions of the head of AAA, that they knew that this violated the alarm code, which is NFPA 72, and none of this was brought to the attention of the customer. The other thing I'd present to a jury to argue gross negligence is the Moore affidavit, the Moore report, and the Moore deposition testimony. Mr. Moore is an alarm expert. He was the expert that was adopted by AAA. And you got to understand the procedural oddity of this. Early on, we sued AAA. We didn't sue ASI, we being Wood Expressions. AAA, in turn, did an indemnity claim against ASI. And they lost. Their claim got limited to $250. Unlike the contract that AAA had, where they had a limitation of liability, of damages, but they forgot to insert a dollar amount, there was a dollar amount inserted in the contract between AAA and ASI, and it was $250. And so their claim got limited to $250, which is obviously a very nominal sum. And at that point, they didn't have an expert on monitoring because they were saying that ASI was negligent on the monitoring. So what they did is they adopted ASI's expert on monitoring, who is Mr. Moore. Well, that was a double-edged sword, okay, because Mr. Moore, who wasn't hired by AAA, he was hired by ASI, was highly critical of AAA. I mean, and this is Exhibit 15 in our summary judgment opposition papers. And that, boy, if I was arguing this to a jury, I'd certainly use that pretty emphatically to argue gross negligence. If you look at, and as I say, it's Exhibit 15 in the summary judgment papers, page 5, Mr. Moore says, AAA contracted with ASI to provide the exact same services to Wood Expression that they do to all other accounts. And that was to notify AAA via email for all system trouble conditions. In other words, a test fail. In other words, the whole system goes down. The remote monitoring service would figure that out when there's a 24-hour test signal, and they don't do it. They don't tell anyone. Okay, the point is this isn't just Wood Expressions. What ASI is saying is they monitor hundreds or thousands of other accounts for AAA, and they're all set up the same way. I would urge the court, if they're interested, to look at Exhibit 15 from the underlying summary judgment papers. There's other relevant language, and this is all covered in our reply brief, and it's on pages 16 and 17 of our reply brief. But let me read you the last part of what we cover. This is on pages 24 to 25 of the Moore report. Quote, and this is, essentially they adopted it. This is their expert. This would cause some major problems in front of a jury. Quote, based on the documents received, it is readily apparent that AAA should not have been installing fire alarm systems in any commercial occupancies. It is also AAA's responsibility to ensure the fire alarm system was code compliant, was permitted by the Phoenix Fire Department, and to inform Wood Expressions that a backup method of communicating to the remote supervising station was important to ensure signals were transmitted in the event of a telephone line failure. Additionally, as stated by Mr. Zwern, who was our expert, this is more. AAA was reckless in advising ASI to not notify Wood Expressions of trouble signals directly, unquote. Because obviously they could have set it up that way. No one told Wood Expressions any of this. So to say that there's not a question of fact, which is what the trial court necessarily had to do, and I can address that issue, the issue of, oh, gee, was this properly briefed? I mean, and I don't want to spend precious time on the procedural background, but, I guess briefly, the other side, AAA filed a very comprehensive motion for summary judgment asserting a whole bunch of issues, and we tracked the same issues in the same order. So the last thing they addressed was gross negligence, so we tracked in our response gross negligence at the end. Well, it was page 21 on what was a 17-page limit. We asked for permission to exceed the page limit. The prior trial judge denied that, and then it went to rotated to the new judge. So, but I'm happy to address it if you wish, but I really think that argument elevates form over substance.
Can I ask you a rather
Yes.
unrelated question? Just the early ruling, there was a suggestion that Section 2G of the contract intended to impose a $150 cap on damages. Is that accurate? And is that? I
guess none of us know what the dollar amount would be. That in the earlier ruling, the first summary judgment ruling and the summary judgment that ASI won, we don't know. I mean, we could probably guess that if they'd finished the sentence, they would have put in a nominal sum, whether it was $150, $250, $500, I don't know. None of us know.
What was your client's understanding of that?
They didn't have an understanding. I mean, these are form contracts. I mean, this is it. It's
so there were no negotiations over that point?
No, this is a classic form contract. Even though this is a commercial transaction, nonetheless, this is an adhesion contract. It's not negotiated. My clients never read any of these terms. They wouldn't, I mean, they.
But if there had been a provision that said it limits damages to $500, would you agree that it would have been enforceable?
Not really, because of the gross negligence. In other words, the same issues.
Absent gross negligence, assuming it's just negligence.
Generally speaking, exculpatory clauses are enforced in commercial contracts. I do agree with that. There would have been other arguments that could have been asserted, such as unconscionability and such. But as a general proposition, exculpatory clauses in commercial contracts are enforced because even though my clients didn't pay attention to any of the form, they are a commercial entity and they're expected to read this stuff. Whether they do or not is another question. But in this case, that's a hypothetical that has no application here, Your Honor, because there isn't a complete sentence imposing a dollar amount. And I just want to point out, we couldn't find an Arizona case law on this, but these exculpatory clauses are strictly construed. Okay, they're not favored.
Right, and I guess my only question, you're suggesting there's no agreement that we did agree on $150 and it just wasn't.
No, there was
never any suggestion of
that. There's no suggestion anywhere in the record that I've seen that there was some verbal agreement that supplemented the failure to complete the sentence in the contract. Therefore, there was a verbal agreement at $150 or $250 or some other sum. And that's what the original trial judge said. It's like, I'm not going to interpose or interpolate or interlineate, if you will, a dollar amount for you. And so consequently, that exculpatory clause did not apply. Now, then they took another bite at the apple in a very comprehensive MSJ where a whole bunch of arguments got asserted. I mean, the arguments that got asserted, now, none of it ended up mattering except the waiver of subrogation clause, but they argued there was no breach, there was no causation. They argued the force majeure provision.
And could you go to the language in the subrogation waiver?
Sure, exactly. Section 2K.
That the customer releases and discharges AAA from and against all hazards covered by customer's insurance. And I'm assuming we could read that. That means a hazard is a fire, so any damage by a fire?
You could argue, you can interpret it one of two ways. You could interpret it that any hazard that is a covered peril there's no way to go against AAA. Now, again, remember, if you look at, you got to look at the contract as a whole. So if you look at 2G, it very clearly indicates there are negligence claims preserved against AAA. It means to limit the damages to some nominal sum, presumably, but it clearly indicates there are negligence claims, and that's what the first trial judge accepted, okay? But if you look at this in context, I suppose if you give the drafter of the contract every benefit of the doubt, which is not proper, you would say if it's a covered peril, then there's no claim. The more proper interpretation we would suggest is if there's a covered peril, to the extent that the insured gets insurance money, if they have losses, yes.
So covered to you means covered under the contract and not paid is not covered under the terms of the contract.
Look, is it possible to interpret it the other way? Of course it is, but it's not clear and it's ambiguous. And Wood Expressions didn't draft it. I think the fair interpretation of it, and I think if you look at it in context, yes, that is the way we would view it. If you have a covered peril, and we cited cases, not from Arizona, but from other places, where these waiver of subrogation clauses got applied, and the court said, and there was one person who had like $1 million deductible or something, or self-insured retention, and the court in New York said, well, that's maybe not very good business judgment, and it wasn't in the context like this, it was a lease, I believe, but the court said maybe it's not real good business judgment to have $1 million deductible, but nonetheless, it doesn't fit within the waiver of subrogation provision. So I do think that if we're going to, and again, there's not a case on point in Arizona, but we cited cases from, from Rhode Island, Illinois, other states. I think it's a fair proposition to say that these clauses, while they are enforced, are not favored and are strictly construed.
But in the context of the amount paid for the service, it doesn't look like there's an intent to, at $30 a month or $40, whatever the amount ends up being, seems very different than an insurance premium covering fire. 2 points there. I mean, that seems to be the genesis for a lot of the case law treating the alarm companies as sort of favored, that they get out from under this a lot, is that the amount is relatively small. First, that's not an exception to the legal analysis that we're talking about. In other words, it's like the law that says that gross negligence is an exception on public policy, or if we apply air freight, that air freight would clearly holds, not apart from gross negligence being a public policy exception, in addition, a bad faith breach of contract is a public policy exception, and they broadly imply that a fraud, like a fraud at the inception of the contract, would be another public policy. The idea that they don't charge much is irrelevant to that analysis. Well, if we were only in, I'm just curious though, if we're just in the land of simple negligence, whether that would that still be your position that?
Well, certainly that would be, if we had simple negligence here in the absence of unconscionability, we'd have a much harder argument. My point to the court is that we have at least an arguable question of fact to a jury on gross negligence. If we apply air freight and go on to the next level of bad faith breach of contract, then I think it's even more clear that we have an arguable question of fact to a jury. You could argue even that there was fraud in the inception of the contract in terms of failure to disclose, and that's where maybe it would be relevant that there was a failure to disclose the delegation and the fact that we're not really going to continuously monitor it, all that. But I've got 2.5 minutes, and do you have any other questions, Your Honors?
You'll reserve the rest of your
I'll reserve the rest of my time, if it's okay.
Sure. That would be fine. All right, when you're ready.
Absolutely. May it please the court, my name is Rita Bustos, counsel on behalf of appellee defendant AAA Alarm and Security. This court should uphold the decision of the trial court granting summary judgment to AAA because the waiver provision of paragraph 2K of the subject agreement is fully enforceable and serves as a complete bar to Wood's claims against AAA. Wood's attempt to invalidate the section are unavailing. Wood admits that the only way that they can continue with their case against AAA is if it's found that AAA was grossly negligent, such that the waiver provision of paragraph 2K is invalidated, or that the waiver provision of paragraph 2K does not apply to uninsured losses. Moving on to the gross negligence, there is absolutely the record in this case does not support Wood's gross negligence argument. Gross negligence.
Let's talk about gross negligence.
Absolutely.
Gross negligence is typically left for a jury to decide, and it's pretty, let's see, it's pretty slight the amount you have to show to get to the point where you get to argue gross negligence to a jury, and I highlighted that part. So we're talking about need not conclusively establish gross negligence, but must present evidence that is more than slight and does not border on conjecture. When we look at this and we look at where he's pointed us in his briefs, we've got the issue that it was a violation of the code, the program to ignore the test fail if there's another error or another communication within 24 hours. We've got all kinds of things that seem to be factual disputes. Who made the decision that they were not going to notify the owner directly? Was that AAA or was that ASI? And I don't think below that was ever really even decided. So let's talk about that for a minute.
Absolutely, Your Honor. In order to really understand that, we need to understand how the alarm system works. And I guess we have the timeline in our briefing, but let's talk about it. Because there was although plaintiff and appellant wants to contend that there was a test fail the night before the fire, there wasn't, okay? They're basing that, so this is how it works. AAA installed the alarm panel at the building, all right? They programmed the alarm panel at the building so that every night at 10:58 p.m., it sends a test signal to the monitoring software. This is to ensure that they're communicating, right? A communication path. So the alarm panel is at the building. That's, where you you open and close the system, you arm it, you disarm it. And then in order to make sure that it's communicating with the monitoring company, which in this case was ASI, they program it so that it sends out this test signal. But the panel is not just sending test signals, right? It's sending all of the signals. So when they open the system, that's a signal that's sent. When they close the system, that's a signal that's sent. And this test is simply to ensure that the communication path is working. Right? So ASI provided the monitoring service in this case. They also programmed the monitoring software. So one of that, obviously the most important thing for the monitoring company and the monitoring software is to see if there's any alarms, that come from the panel. But they also want to verify that there's a communication path. So that way, if there is an alarm, you get notified, right? So ASI programmed their software so that every night at 11:58 p.m., it's testing. So that's the test, right? So it's sending out this test and it's looking for communication from the alarm panel.
What happens when a phone line is cut?
Well, okay. So if a phone line is cut, then obviously the communication path has been cut off, right?
So shouldn't there be a notification? Isn't that what you would want if you have an alarm system? Don't you want to be notified that the phone line has been cut if that's involved with the system?
Well, of course, Your Honor, and that's why we get to the point of any signal can be a test signal. All of the experts, including plaintiff's expert, testified to this and verified that when you're testing the communication path between the panel and the monitoring company, any signal can be a test signal, and that makes sense, right? So in this case, the timeline of what happened, the monitoring software checks for the signal the night before the fire, and they find the closed signal, and so the system is satisfied, and that's how ASI programmed its monitoring software.
But you're suggesting that maybe ASI should have done something different, and you actually pursued claims against ASI.
Correct, Your Honor.
So why would that not be attributable to your why if you're the owner, the property owner, and you've hired a company, the fact that they subcontract something out to someone else, why would that excuse liability under?
Well, and Your Honor, it would not excuse liability, but that goes to the issue of whether it's simple negligence or gross negligence, right? So what we have specific alarm cases from around the country that say that the failure to detect a signal is not gross negligence. That's the Valenzuela case.
There's an allegation here, though, that there was a directive on how to program on how the system was to work. Why wouldn't that be a jury question?
Well, and again, because AAA did not They did not direct, and again, that's incorrect, to say that AAA directed ASI to program its software in any specific way. Wood's alarm expert himself, Jeff Zerwin, also testified that the flaw, if it is a flaw in ASI's programming, which again, a problem in programming of software is not gross negligence. This is what the cases say. If there was any flaw in the software, this is what ASI...
If it's a flaw that renders the system entirely useless, I understand I'm exaggerating here, but if the alarm company or if the company that's the subcontractor has done something so it simply doesn't respond, if it waits and doesn't respond for 3 days, I mean, why wouldn't that be something that a jury could consider and just say, this is how it was programmed. We don't get notification for 3 days or until we receive a notification from a fire department?
Well, Your Honor, I don't know where maybe the 3 days is a hypothetical.
Complete hypothetical.
Okay. Yes. So again, we're talking also about knowledge and what people knew. And appellant wants to make it seem as though ASI, AAA knew that this system failed and didn't say anything, didn't do anything, didn't inform the customers, had a policy of not informing the customers. And my point here is that's not correct. There was no test fail the night before the fire.
But isn't there some evidence that suggests that may have been the directives given to ASI in terms of how to program the system?
No, Your Honor, that's not the indication. The only indication is that you can consider any signal a test signal. AAA never told ASI, ignore test fails, number one. Okay.
But
number
isn't that
two,
enough? You can consider any signal to be a test signal. And if it's a signal that the phone line has been cut.
Well, that's the other part of it. There was no communication to ASI or AAA. They had no knowledge that the phone line had been cut.
And I want to make sure, sorry to come in here. I want to make sure I understand, because I think I read somewhere in the briefs or in the record that test signal 2 between ASI and Wood had never been missed, that 1058 test signal. So wouldn't this put them on notice?
Okay, so that's not, well, again, and I mean, we do have the entire alarm monitoring logs. I cannot speak to whether or not that test signal, the point is that it wasn't a missed signal, right? It's the line was cut, the communication.
It was a missed signal. You don't count it as a missed signal in your software programming, but the signal was not received. So it was missed. Oh, technically.
Okay, but the point is that all of the experts testify that any signal can be a test signal, and the communication path for that period was verified with the closed signal. And everybody says that all the experts testify that that's fine under the code. And also, we have to look to the law of gross negligence. Appellant has not cited not one alarm case, okay, to suggest that what happened here is gross negligence. And it just isn't. And the alarm cases that we cite, Valenzuela, Fireman's Front, Hartford, missed signals, delayed responses to actual alarms are not gross negligence. It does not rise.
Those seem pretty fact-specific, whereas it seems to me the allegation here is the system has been set up incorrectly. That seems very different than we missed it in this particular case. Somebody got the wrong address or something.
Well, with respect, Your Honor, the Valenzuela case talks about programming, right? So in that case, for some reason it was coded, it was programmed such that the alarm customer was coded out of service. So with an actual alarm in that case, okay, they were not notified. In this case, it's something very, very different. This was a test signal. The test signal had been satisfied the night before the fire. The night of the fire is the only time that there was an actual test fail, which was verified, and the customer was informed of that. Of course, at that point, the fire had already come in. And I do want to point out, again, the issue of gross negligence was not only decided by Judge Contis in this case, it was also decided by Judge Gerlach. The information on gross negligence was already decided in this case. We had a gross negligence issue, and you can see that in the April 16th, 2016 transcript of oral argument. And we point this out in our reply in support of the motion for summary judgment. Judge Gerlach considered all of the issues in this case, and, they said and this is from his...
He issued a ruling saying there's no...
He has a ruling that says there was no gross negligence on the facts of this case. So that issue had already been decided by Judge Gerlach. Of course, that was between ASI and AAA, but it's based on the same facts of record. So Judge Gerlach, he says, the assertion is that there was a failure to detect the alarm. That should have been detected. What explains that failure? ASI's failure to comply with the applicable standards and codes. But what he says, based on the cases that he's read, which we've cited in our briefs, a failure to detect is not gross negligence unless there's some accompanying fact showing that the failure was willful or knowing.
If the allegation, though, is this was some directive from AAA to ASI, then Judge Gerlach's ruling wouldn't have any significance.
No, and Your Honor, and that's incorrect because, again, there was no directive from ASI or from AAA to ASI to ignore test fails. And number one, again, we're going back to the point of there was no test fail. There was no test fail the night before the fire. The only test fail, was the night of the fire, and that was after the fire was already detected. So please, we really have to go back to that because this whole issue of...
But so you're saying there's never a failure when the phone line is cut, that you have there's no need to
I'm
notify
sorry, Your
anyone.
Honor. Sorry. Okay. No, and that's the point. That's not a test, right? That's the alarm, and okay, fine. The phone line is cut. That means the alarm is not communicating. But we already know that phone line was cut by an unknown intruder that has nothing to do with AAA. But it's all about knowledge, right? So there was no knowledge. ASI and AAA had no knowledge that the phone line had been cut, and they set up ASI set up the programming software to look for the communication path, found the closed signal, and it was satisfied for that day. So if anything, maybe it's a programming error, but again, if you look at Judge Gerlach's analysis, going back to this, whether it's a programming error, he cited oh, yes, Your Honor.
We aren't bound by Judge Gerlach's interpretation of case law. So let me ask you this. Let's take this out of the context and the facts of this case. When would a failure to notify in an alarm context reach the point of gross negligence, in your opinion? What would it take to get there that's missing here?
Well, okay, of course, if there was an actual alarm system, an alarm signal going off and it came through, there was knowledge of it through to the monitoring company, and then they specifically didn't tell the customers about an alarm going off, then maybe that would rise to gross negligence. Or if we look at the Arizona cases on gross negligence, which are not directly on point, but again, they go to the knowledge, the willfulness of what's going on here. So, for example, I think it was the Weatherford case that appellant had cited, where it was the softball field, and the lights had been out on the softball field for 4 or 5 days, and the city knew about it, and they knew that it was an issue. They did nothing about it. So there was enough there to find for gross negligence to go to the jury. In this particular case, we don't have that. Friday, the test signal on Friday night, there was no test fail. The only test fail in this case came the day of the fire, and all the experts agree that any signal can be a test signal. ASI and AAA had no knowledge that the phone line was cut. Okay, so again, it may come down to a programming error, a simple programming error, which again, all of the alarm cases say does not rise to gross negligence. The gross negligence is a very, very high standard. I think, Judge Contest probably said it best when she cited the Scott v. Scott case. It's highly potent. It's in the air, so to speak. It's flagrant and evinces a lawless spirit. And if we go back to Judge Gerlach's ruling, again, he said, well, there's something extra here, right? So ASI programmed its monitoring software to look for any test. It found the closed signal, and it satisfied the system.
Your client was suing ASI just on a gross negligence or simple negligence?
Well, ASI, we brought ASI into this case obviously because they were the ones who programmed the monitoring software. And so, and all the entire issue in this case is about the monitoring software and the programming and everything. But we lost that gross negligence argument because there's no gross negligence in this case. And AAA, again, we'll go back to the point that
you said you lost the argument. You made the argument that ASI was
we made
grossly
the
negligent.
argument that ASI was grossly negligent, and we lost it. That's what the April 16th, 2016 transcript of the proceedings from Judge Gerlach, we have his opinion cited in our reply brief. I mean, he really goes through the analysis, a very detailed analysis of the gross negligence in this case. And I'll just mention Mr. Moore, which appellant cited. First and foremost, Mr. Moore was not our expert. Okay, so that's an important thing to distinguish. And then,
but
you know,
he was ASI's.
He was ASI's
who
expert.
You brought in and
exactly
subcontracted with.
Exactly, and you know, appellant cited his report, but at his testimony, he walked back a lot of that what he said in his report. So, for example, he testified that ASI's handling of the no test, including the notification email, and again, we're talking about the no test on Saturday because there was no test or a test fail on Friday, the night before the fire, complied with the fire code. So that's Record on Appeal 616, Exhibit 24, which is Moore's deposition. The email notification of the no test, which is how ASI programmed, right? So if there was a no test, if it came up on their monitoring, because we have all the monitoring logs in the record, and it shows, you know, what happened in this case. You know, sending an email to the designated representative of the customer. So in this case, the designated representative of Wood was AAA. So sending an email, again, it's the most common way in this industry. That's also what he testified.
That's sent to you, but then not communicated to the
Customer.
Well, and again, the test fail, and again, we have to go back to the point.
And I'd like to hear your thoughts on the subrogation waiver, the language there, and would like to know, in the context of any dollar amount being left out of a cap on liability, doesn't that suggest that that your client did understand that there was some potential for liability? It was going to be limited to a specific amount. You're reading this against all hazards. You're saying, so if there's a fire, that we can't be liable for anything having to do with the fire?
Correct, Your Honor, and that comes from the plain language of the agreement. And because we're getting onto that second issue, which is the uninsured
loss. But it says hazards covered by the insurance, and if the insurance only covers claims up to $50,000 and there's a $100,000 loss, would you say it's covered because it's a fire and fire is covered as a... But don't would you agree that you could read it the other way, that covered by means the insurance paid that amount? And this was a contract that your client presumably drafted. Wouldn't we construe it against your client if it can be read two different ways?
I mean, Your Honor, respectfully, I believe that the contract language is pretty clear, and that's exactly what Judge Contest had found, the difference between hazards versus losses. The hazard is covered, so whatever the monetary amount is, it doesn't really make a difference. The hazard is covered. And really quickly, I just want to say something.
Does that mean that there's just zero liability for anything? Why would you need why would you need a cap on damages? If you're saying any hazard, doesn't matter that we're an alarm company. If we don't do anything to notify the customer, as long as you got fire insurance, that's on your fire insurance carrier.
Well, that's not necessarily the case, right? So if it was we're saying this is simple negligence, the 2K applies. If there was a finding of gross negligence, we understand that the waiver provision wouldn't apply. I'm not sure if that's what you're getting at.
Okay, I'm just saying let's be in the world of, and can we give them each maybe an extra minute or two, but it's world of simple negligence. And you're saying that this provision would say there's zero coverage for our simple negligence. If we do something wrong, we're not liable at all because this says you're supposed to have insurance to cover what we're trying to warn you of, and so you've got to look to your insurance carrier to cover the fire damage. It doesn't matter that our system just doesn't work. There's no damages. available to you. Is that?
Yes, correct, Your Honor. That is correct. That's the waiver provision does apply, and those are routinely upheld, and we have all of the case law citing that, especially Judge Contest does look at that case law as well.
Why not be a little more specific and say that, as opposed to leaving it to losses covered by, which could mean to the extent insurance pays something, you can't recover it from your company. But if the insurance doesn't cover it, when it says losses covered by insurance, why not specify, and why not put a cap? Why not put a simple cap and say your coverage is capped at $1,000?
And, Your Honor, honestly, I could not answer that question as to why the contract was drafted the way it was, but it was drafted that way. All hazards are covered. This was a fire hazard. All of the losses from the fire hazard were covered by appellant's insurance. Therefore, the waiver provision of 2K applies. And really, that's not even an issue in this appeal, because that's not something that they argued in their opening brief, saying 2K doesn't apply at all. They're only saying it doesn't apply if there's gross negligence, and it doesn't apply if there are losses, uninsured losses, which are not even defined.
But that is, they are suggesting that it's, if we had insurance, but the insurance only covers half of our losses, then we think this allows us to recover the other half.
And respectfully, I would disagree. I would say that the hazard, the fire hazard, is covered. They choose their insurance coverage.
You could have, don't you agree you could make that much clearer in that sense, which is a contract that your client drafted?
I could not disagree with that, Your Honor, but it is pretty clear that all hazards are covered. If we look at Judge Contest's opinion, she goes all the way into that. And I do just want to say one thing, and I know that my time is up, about the standard of review for the uninsured losses argument, because that argument was only brought up in the reply in support of their motion for clarification, which truly was a motion for reconsideration, and the actual standard for review for this court would be an abuse of discretion. Whether or not the trial court denied it was an abuse of discretion.
Thank you, counsel. When you're ready.
Thank you, Your Honor. All right. First, as you point out, Judge Catani, if someone wanted to, they could draft this provision so it was crystal clear. This is anything but crystal clear. And you asked appellee's counsel, would you agree it could be read in a different way? It could be read so that it only is a waiver of subrogation to the extent that the customer actually gets money from the insurance. You use the example of $50,000 of coverage and $100,000 of loss. Well, I mean, you could have a more extreme example, $50,000 of coverage and $1 million loss. You know, the point is, it's whatever scenario we want. Opposing counsel didn't answer that question. Clearly, eventually, though, she said, obviously, it could be more clear. It could be more clear. And the question is, why in the world do you give the drafter of this strictly construed exculpatory provision the benefit of the doubt? I don't think that is consistent with public policy. Everything I heard from the other side is like just highlights questions of fact. Who chose to set, look, let me be clear about something. There was a test fail Saturday night. It was ignored. I think you alluded to this, Judge Campbell. There was a test fail Saturday night. It was ignored because there was a close signal earlier that night when Mr. Potter left the premises. So there was a test fail. It's in the record. There's like this long document showing the test signal every night for years at 10:58 p.m. Years and years. And the first time after years that it doesn't happen is Saturday night. And then the next night, it happens again. Now, Saturday night was ignored because the system was set up to ignore it. They say, oh, it's ASI's fault. Now, just to be clear, the record is abundantly clear. ASI says the opposite. ASI says you could have set that up differently. You chose to, check a box for any signal to be a test signal, and therefore it was ignored. But if you wanted to, you could check a different box, and when that test fail came in Saturday night, which it did, it was ignored, but when that test fail came in Saturday night, someone went on the phone to the insured within 2 minutes, I believe is the standard under the alarm code, 2 minutes, okay? Instead of, you said 3 days, Judge Catani, the actual reality of this is almost, you said 3 days, the actual reality here is going on 2 days. Saturday night, Sunday night, and then the email goes out sometime early, like 4 o'clock in the morning on Monday. So I do think
wasn't the email after being notified from the fire department?
I don't know why the email was after that. The way my clients got called is it was a policeman who saw smoke and went there, and then he heard, the system is still working. It's just not in contact with the remote station. So when the place is burning down, alarms are going off and sirens and all this jazz. And so the police officer goes there, and there's a placard saying, call AAA. Well, when you call that, it's not AAA, it's really ASI, okay? He calls ASI, thinking he's calling AAA. ASI now has been called and told by a police officer, hey, this place is burning down. So then they call Mr. and Mrs. Potter, the owners of the business, and they get in the car, and it's 12:30 at night or something, and they drive down there. So that's how, and then the email, talk about closing the barn door after the horse is like long gone, the email goes out sometime like the next morning at 4 a.m. And the first time anyone figured out that the telephone lines were cut was when people the next day on Monday are pushing through the fire debris, and I think it's Livingston is the guy's name, the owner of AAA, realizes, the phone lines are cut. It's just classic after the fact, okay? My only point is, I don't know if a jury will accept this gross negligence argument. I just think we are entitled to make it.
So when we look at the timeline, let's make sure we all have this correct. Saturday, 6:44 is the closed.
Yeah, he left the office.
Saturday, 10:58, no signal.
Correct.
Sunday, 10:58, no signal. And midnight Sunday is when the officer finds the fire.
Yes, that's the timeline. And there was no question. Now, one critical point here that we talked about Moore, okay, if they don't have Moore as their monitoring expert, they don't have a monitoring expert. But in any event, Moore ended up admitting, so the idea is that any signal can count as a test signal. That's what the code says. But it doesn't just stop there. It says any signal can count as a test signal if it's monitored by a human being. These are not. This is automated. And what Mr. Moore ended up admitting at the deposition when I asked the questions is that, well, what about this provision, sir? And this is I think it's in our opening brief, but he admits I didn't think about that. I'd have to rethink all my premise for my theory.
All right,
I'm out of town.
Time has run. Counsel, we thank you both for your arguments. We will take this case under advisement, issuing a written ruling in due course. Be safe. Replace your mask when you walk out into the public areas. We are at recess.
Thank you.